Good morning. May it please the court. Jane Grossman on behalf of the appellant Brian Gilroy. I would like to reserve 3 minutes for rebuttal, please.
Okay.
We come before the court this morning, Your Honors, with two main issues. The first has to do with the trial court's denial of the former husband's motion for continuance. The second group of issues that we bring before the court have to do with the manner in which the child support was calculated. To give you a very brief history of the case, these people were divorced in 2007. In 2012, there was a child support modification action, and it's important to note that we know exactly what happened in this case because there's a transcript of that 2012 hearing that's been filed with the court, and we also have the appellate record showing what was filed at that time and what was not filed at that time. Basically, in the 2012 action, the parties declined, over the trial court's expressed concerns, declined to file any type of child support worksheet. And in fact, the trial court judge, Judge Shames, said, you know, I'm concerned because if there's a future modification action, there's going to be absolutely no benchmark for determining where we came from and where we should go. Nonetheless, the parties did not file any type of child support guidelines worksheet. Basically, they agreed that the former wife, a physician, would continue to pay the private school tuition. She would continue to pay all of the health insurance for the children, and the former husband agreed to forego the $700 to $1,000 per month child support that he was entitled to due to the great disparity in the parties' incomes. We then have the instant action, which involved a relocation of the former husband to Arizona. He filed a supplemental petition to modify the time sharing. The former wife filed a counter petition and very loosely asked that the child support be modified. Notably, however, she never referenced a change in her income, never asked that the trial court deviate from any type of guidelines calculation, and she never at any time asked that the former husband be responsible for the private school tuition.
How long before the hearing was that filed, the counter petition?
The counter petition was filed approximately 6 months before the final hearing. I believe Mr. Gilroy filed his supplemental petition in November of 2013, and then the former wife timely filed her counter petition.
All right.
The final hearing was scheduled for May 9th, and it's undisputed. This was not at all disputed at the time of trial or in the answer brief, but the final hearing was on May 9th, and the evening before, as Mr. Gilroy is getting off the airplane at Tampa International, he receives an email which attached the financial affidavit of Dr. Gilroy, the former wife. She had never at any time in the 6 months this case was pending filed a financial affidavit.
Neither party had filed financial affidavits?
Yes, he did. In fact, the trial judge had the very same question of Mr. Gilroy, and he said if you look back at the time I filed my supplemental petition in November, I did file a financial affidavit, and they resolved that issue at the trial court.
Because I think in the answer there was an indication that the husband has failed to file a family law affidavit, so that was incorrect? That was determined to be incorrect?
Yes, he did in fact file a financial affidavit.
The answer also indicates child support should be reduced consistent with the current income of the parties and the reduced number of overnights. At that point, what was the child support?
The child support at the time of the most recent filing?
At the time of the answer by the
former
wife.
The child support was zero. Actually, Mr. Gilroy was entitled to child support even though he was not the primary residential parent because Dr. Gilroy had such a high income. He was entitled to $700 to $1,000 per month child support.
My question really becomes, at that time there was zero child support being paid. There is this allegation that child support should be reduced from zero, I guess, consistent with the current income, but it raises the question of current income. So that begs the question, was that enough to put your client on notice that he needs to do some discovery as far as the current income of the wife, and what did she mean by saying that it has to be reduced consistent with current income?
Well, the reason why we have mandatory rules of discovery is because we don't want to have this type of issue, that somebody can loosely file an answer to a counterpetition or a counterpetition and say, oops, child support should be modified based upon the incomes of the parties. What does that mean? We have 12.285 of the family law rules which require mandatory disclosure. And mandatory doesn't mean, well, it's mandatory only if you have somebody on the other side who complains and says, we really want you to do it.
But
it's
to
mandatory.
play devil's advocate for a moment, your client had an opportunity to file a motion to compel the filing of the affidavits. I mean, he could have done things to move it forward. The question becomes, was he on sufficient notice that this was going to be an issue?
Yes, and I respectfully argue that loosely saying the child support should be modified due to the incomes of the party in no way justifies filing a financial affidavit that was due under the mandatory rules months before, the night before trial, and it shows that the Dr. Gilroy's income, which according to her expert, her annual salary had been anywhere from $400,000 to $500,000 for the past 5 years. The night before trial, she files her financial affidavit for the first time, and she has seasoned counsel who knows what mandatory disclosure is. Her income goes from $439,000 in 2013 to $250,000 on this financial affidavit. And adding in,
based on a projected 3 months of income though?
yes.
Is that enough to show a change?
Well, I've cited to the court the case of Freeman versus Freeman decided by this court, which addressed that very issue. And they went into what exactly is a permanent change of circumstances, and basically said, we need to look an extended period of time. But the point I'm trying to make is...
And the reason I asked you about when they raised it, at that point in time began after the answer was filed, apparently, if I've got my timing on this right.
Pardon me?
The timing of the decrease was like beginning in January or February of a year when the answer seeking modification had been filed before that point in time. So the change occurred
Yes.
after the answer was filed.
Exactly.
And while I have you interrupted, something you said caused me to... I've not really looked carefully at the 2012 order. My impression from listening to all of this is that the order actually orders no one on either side to pay child support, that the agreement is that the wife will cover certain things, and as a result of that, neither one of them pays support to the other?
Yes. Yes. And there's a transcript of... There's a transcript of that hearing where Judge Shames is saying, I'm really bothered that you're not filing these guidelines, and the parties just simply choose not to. But I would point out to this. This is what I believe is most objectionable legally in this case, the way these 2012 guidelines were introduced into these most recent proceedings. If the parties had in fact agreed that in 2012 private school tuition was going to be a line item on the guidelines, you better believe that those guidelines would have been filed in 2012, because that would have been a home run. They were not. For some reason, they were held back. Nobody wanted them filed. And then we come to the most recent proceedings, and for the very first time at trial, the former wife says, oh, by the way, Judge, these people have already agreed that we're going to ignore basically Chapter 61, which tells us how to calculate child support, and we're going to put private school tuition as a line item, just like health care, just like daycare. And Mr. Gilroy is like, wait a minute, I've never seen any 2012 guidelines. I had an attorney at mediation. I had an attorney at the 2012 hearing. I've never seen any guidelines that included private school tuition as a line item on child support guidelines. And at that point, it's very clear why this was attempted, and to the former wife's credit, they were successful. It looks like the parties at some point had agreed that this was going to happen, and in fact, it never did. What the judge did was allow something to be introduced in 2014 that could have and should have, but didn't, was not filed back in 2012. And that's just clear error. I mean, not only does the 6116 clearly require a financial affidavit, 6130 tells us how to calculate the child support guidelines, and it lists exactly what's included, and subsection 7, subsection 8 are the only line items that can be added to the basic child support. That's it. Never has private school tuition ever been a line item on the child support guidelines.
If there was an agreement, though, that private school tuition would be paid and would be shared in some way, it would be appropriate to include it at that point, correct?
Well, I don't know that it would make a difference whether it was included.
But ultimately, the trial court would have to determine, was that an agreed
Yes.
agreed amount by the parties.
Absolutely.
So if we were to reverse on the continuance issue and on the 3 months of income, or basically say, well, there should have been a continuance so there could be discovery, wouldn't everything end up being reversed anyway?
Yes, absolutely. What we would like to find reversed is this finding that there's been a substantial change of the wife's income, because that was not pled. What we'd like to have...
If there should have been a continuance, that could all be pleaded. I mean, the case basically would start over, it seems to me, because people can move to amend their pleadings. You know, the allegation is fairly broad as far as the current income should be used to determine child support, but it
Yes.
does seem to me both parties would, on a reversal, have the opportunity to flesh out whatever they wanted to.
Absolutely. But I think one of the most important issues is whether at this point, when clearly the record is devoid of any suggestion to the contrary, that Mr. Gilroy can be ordered, absent an agreement, ordered to contribute to private school tuition at this point. It wasn't done in the divorce. It wasn't done in 2012. So absent some type of agreement, I don't think the trial court has any jurisdiction whatsoever to throw private school tuition in the pot.
But why couldn't the trial court determine that part of the 2012 compromise was based on the tuition component, that she was going to pick it up and she wasn't going to have to pay him child support, because essentially the money is going from one pocket to the tuition pocket?
Well, I thought about that, and this is a point. There's a huge difference between Mr. Gilroy in 2012 saying, you know what, she's agreed, she's paying all of the health insurance for the 3 children, she's agreeing to pay the tuition, I'm going to forego my $700 per month child support, as opposed to Mr. Gilroy saying, I now agree to be responsible for the private school tuition of 3 kids.
Be an issue.
That's a huge difference.
That would be an issue of fact for the trial court to determine.
Absolutely, but I don't think...
You're suggesting, though, that she's precluded from raising that issue. It doesn't seem to me she'd be precluded from raising the issue. Ultimately, the trial court would have to determine what was the agreement between the parties, either in 2012 or before. Why would that be precluded?
Well, for the very reason that in 2012, these parties went through lengthy proceedings, okay? This issue could have been put to rest if the parties had filed guidelines and had an order.
But both parties suffer from that.
Yes,
I mean,
absolutely.
your client doesn't get to say, well, they didn't pursue it, so therefore I get the benefit of it. He didn't pursue clarification that he wasn't ever going to pay for private school tuition.
Correct. But I'm just pointing out there's a huge difference between saying I'm going to give up my $700 a month child support versus I'm going to now contribute to $1,667 per month for each of the children who are in private school. That's not the same thing. And adding insult to injury is the fact that we have the guidelines that took effect from June of 2014, effective to September of 2014, that say, Mr. Gilroy, you're going to contribute to the private school tuition of the oldest child, Molly, Molly graduated in June. She already started college in June, but yet the guidelines that the $1,432 is based upon, if you look at the guidelines, it includes for the oldest child, Molly, private school tuition of $1,667. Clearly, that's error. That should have never been in there. So that needs to be.
Was that error pointed out to the trial court?
I don't think he filed a motion for rehearing as to that.
I mean, but even there was testimony at trial where the documents were offered, and there was testimony based on what the documents showed, and I don't recall him objecting to any of that.
No, and to be honest with you, Judge Silverman, when I read the transcript of that final hearing, there were so many worksheets flying back and forth. I don't know that anybody really understood which one was being used, because we had 3 sets, and then as people were presenting one, the CPA would say, oops, no, I made an error, here's another one, and then Mr. Gilroy said, well, no, that's not my actual health insurance. So by the time after the hearing that the worksheets were submitted, that's when the error became apparent, and it needs to be corrected.
If we reverse the order on appeal, what is the trial judge supposed to do on remand? What's the nature of the proceeding going to be on remand?
It's going to have to be a de novo, start all over again. Allow Mr. Gilroy to conduct discovery.
But a de novo on, I guess, on what? I mean, it's almost as if we don't really have, the trial court seems to have decided in 2012 not to have a child support order because the circumstances were such that it was in the best interest of the child to have this agreement for certain things and not a child support order. Does that mean we go back and have a hearing on child support as if we were at the divorce at the beginning of the case? Or I'm not sure what we try to, if we do it as a modification, I'm not quite sure who proves what. And so I'm anxious about just reversing and sending it back to the trial court to tell her to have a good day. I think we need to tell her something more than that.
Well, unfortunately, I don't know how you're going to get around it. I think it has to go back to the point of this most recent supplemental petition for modification. I don't know how we could ever go back to 2012.
Your client's petition was simply on the visitation, basically the visitation aspect, is that right?
Yes.
And then the other side brings up, well, if there's going to be this change, you also need to know there's a change, arguably a change in income, and you're going to have to recompute child support based on all these changed circumstances, some of which are not fully pleaded, some, your client's clearly is fully pleaded.
Yes.
And so it seems that in response to Judge Altenburn's concern, it's basically we're working from a petition and a counter petition, and it's going to be for the trial court, if we reverse, to allow discovery, and then if there are modified pleadings, they're going to tee up whatever issues have to be resolved.
Yes. Yes.
But I think Judge Altenburn's concern is, does the court have to go back to 2012? And it seems at least arguable that they might have to, because nobody knows what the guidelines worksheet was in 2012 other than Mr. Maros tendering, well, here's what we had, or here's what we have.
Right.
Which your client would want to challenge, I guess.
Yeah, and I'm trying to think in my mind why we would have to go back to 2012, though.
Well, Judge Shane said it. Judge Shane said it. There has to be a baseline.
Well, if you look at just child support, we don't need to go back to 2012 because we have the parties' incomes as of the most recent supplemental petition. The only reason you'd have to go back to 2012 is on the issue of the private school tuition.
Well, and on Mr. Maros's client's contention that her income has changed, and so you have to look back, well, what was her income then, what did the guidelines provide for then, and what's her income now, and what do the guidelines now show is the appropriate change? We
could. I don't think it's necessary just for child support. If it were alimony, I think that would be more important. But I think just for child support, if they can establish an extended change of circumstances, then you just apply the guidelines to what the current income is and make it retroactive.
I'm going to save you a couple minutes for rebuttal. I need to get you to sit down. Thanks.
Pardon me?
So if I'm going to save you some time for rebuttal, I think I need to get you to stop.
Thank you.
Thanks. Mr. Maros?
Good morning, Your Honors. I have the fortunate experience in this case of having been involved going back to the 2012 time period and I say with all due respect for counsel who often handles appeals and only appeals only, that she's operating from a significant disadvantage. And in this
She's
case,
operating from the same advantage we have. We review these cases on the record and only on the record. If you know lots of stuff outside the record, that's swell for you, but it's not for us.
well, you know I would never talk
Yeah, no,
about anything
but I'm
out of the
understanding
record.
that.
But I'm telling you things that are in the record that counsel simply doesn't understand, and I'd like to explain to you right now. First of all, before we get to that point, I think there was some mention of our pleading being casual or vague or something, and I would completely disagree with the pleading being anything other than completely straightforward.
Did your pleading allege a change in income?
It doesn't have to allege. No, it doesn't. But it definitely doesn't have to
If you're
allege.
asking for a modification based on change in income, doesn't it have to plead that?
No, sir. All you have to plead is based on the current income of the parties, which is what the law would be once you've gotten over the hurdle of substantial changes in circumstances.
And to support that petition, doesn't there have to be the financial filings?
There definitely has to be proof.
Were the financial filings made in connection with the counter petition?
Well, here's exactly what occurred. You correctly stated or asked the question, neither party filed a financial affidavit, did they? Well, in fact, what occurred was we never got a financial affidavit from this gentleman until the day of the final hearing. What happened was that he filed, when he filed his petition, a financial affidavit. It wasn't served on us. We never got it. We never saw it, didn't even know it existed. And I would respectfully suggest that that often is the case, that you don't necessarily get something that's been filed. So we had no financial affidavit, nor did they. There are reasons behind both of those, but they're not in the record. The bottom line is that in this case, as in hundreds of other cases that I've tried throughout my lifetime, we agree, this gentleman who is the furthest thing from an unsophisticated litigant, one of the most highly degreed and titled attorneys I've ever heard of, and experienced in litigation in this case on 2 occasions, we agreed on a process. The process was no pretrial. The process was no witness list. The process was no document exchange. We showed up with our stuff and went to trial. There's nothing wrong with that at all. Nothing violates the rules in any respect with regard to what we did. We had our evidence. We submitted it. It was extremely competent, substantial evidence. Everything that the judge ruled on in this case was 100% supported, almost without contradiction by the testimony that was offered at the time of trial.
When you said there was an agreement not to exchange documents and information, who was that agreement with?
It was done in the classic manner, which is that instead of setting a pretrial, and on a fairly expedited basis.
That was for these pleadings?
Yes, sir. We
Because
simply set a trial.
The other side was pro se, or
Yes.
was he only pro se at trial?
No, he was not pro se in his prior proceedings, but he was pro se throughout the course of the supplemental proceeding.
So are you saying you reached an agreement with him not to file anything?
Yes, sir.
And is that admitted on the record?
Well, the record establishes, and I've got the dates, there was a notice of hearing sent out in February of 2014, some 40 days before the trial on May 9th. The way procedurally that works is you set a trial. Sometimes the judge will require pretrial, sometimes they won't. No pretrial was required in this case. No witness lists were ever exchanged. No document lists were ever exchanged. Nothing wrong with that at all. And as a matter of fact, this gentleman had every opportunity to ask for any and all of that he wished, as did we, and the judge would have accommodated him.
And I'm not certain if I understand, but was any of that part of the so-called mandatory discovery under the rules?
I'm not sure I understand. No, sir, it was not part of, mandatory disclosure is something that is required, but in fact can be waived and often is waived. And there were, as this judge correctly said, it's a classic example of why the judge has superior positioning in this sort of thing, is everybody knew what was happening here. This gentleman had every opportunity to conduct any discovery he wanted to conduct. You don't show up at trial and file a motion to compel. You don't show up at trial and say, where's my financial affidavit? If you do, it falls on deaf ears, because you've had 6 months in which to conduct the discovery, then you've had another 40 days after the case has been noticed for hearing in which
One of the things that concerns me, and I alluded to this in my question to opposing counsel, your pleading says child support should be reduced consistent with the current income of the parties.
Yes, sir.
And at that time, there was no child support being paid on either side, correct?
No, sir, really, that's sort of a semantic argument, and again, this is fully reflected in the record. It's on pages 10, 11 of my brief, and I think it's on pages 66 and 67 of the transcript. Here's what occurred. What occurred was that we had a hearing set for trial all day in 2012, and this is not only in the testimony of Mr. Berg, who was the CPA who did the guidelines in 2012 and did the guidelines in 2014. The guidelines, if you take into consideration $20,000 worth of tuition for each child, the cost of the medical insurance being provided, and the differential in income with a 50-50 time sharing, that child support actually was owed, including the tuition, unequivocally including the tuition.
But as Judge Shames pointed out, not in this way, but we don't really know all of that. I mean, we know it because at the 2014 hearing, there is a tender of guidelines that had not been introduced in 2012, correct?
Yes, sir.
And we understand that there was a settlement agreement reached at mediation, and it was a compromise, and everybody acknowledges there was a compromise. But what the give and take was, we're not fully, at least as of 2012, we don't know, right?
No, sir, we do know. We do know specifically, starting on page 66 of the transcript, where we talk about Mr. Berg's, and this is his testimony at trial, and then again his testimony at that other hearing was offered into evidence. Mr. Berg, you participated in this case in 2012 and 2014. You drew the guidelines then. We reached an agreement then. You've drawn the guidelines now. Did the guidelines then and now, did you use the same process, and did they include tuition? Yes, they did. Did they include medical insurance? Yes, they did. Mr. Gilroy, at the same time, also in my brief, Mr. Gilroy, did you understand what we've just done today? That was back in 2012. Yes, I did. Do you understand the terms of the child support, the private school, and the medicals? Yes, I do. Do you want the court to approve this agreement? Yes, I do. There is no doubt that child support was being paid. It was just being paid indirectly from tuition, medical insurance, whatever. It's often the case. It's often the case that the majority of private school tuition, extracurricular activities can eat up the child support. So in fact, my client, just as I stated in the pleading, was seeking a reduction consistent with the current income of the parties, and specifically pled consistent with a change in the overnights, consistent with a private school tuition that would establish appropriate child support. That's what you need to plead. That's what I did plead. That's what we proved at trial. If this case were sent back to the judge, there is absolutely no basis for a result of anything other than what she already did.
Mr. Morris, let me ask you a question about the reduction in income. Yes, it looks like that there was a projected reduction based on a 3 months period. Is that long enough? Is that a permanent reduction?
Sure. Well, I completely understand the question, and the answer is yes, because it's based on competent substantial evidence. Again, in my brief and in the transcript,
It's not the income she was making when she filed the answer, saying that based on current income she wanted a modification. It's a change in circumstances after that time that you never pled or put anyone on notice that there had been this big change in their income.
Well, you're never going to have a total baseline for what the income is. I mean, you file a supplemental petition in 6 months, and it's heard later in 6 months. You're going to routinely update financial.
Do we have a case that says that 3 months is a permanent unexpected change?
No, there's two
this
things.
Is not alimony, but yeah.
Two things to be dealt with. I really, in all due respect, don't think we need a case on that because of the testimony of Mr. Berg. Mr. Berg testified, I'm very familiar with this doctor's income. I go back to 2011 with her income. I know what it's been. I know that it's varied. I have now gone back and reviewed her 2014 income, and based on a variety of things that he testified to, specifically insurance issues, government issues related to the new Obamacare, that her only recurring income for 2014 was going to be based on that 3-month period. It wasn't going back to 2013. It wasn't going back to 2012. And we have cases like this all the time where short-term income is reflective of recurring income going forward, where there's been a real reason for it. And here, an answer to your question is, yes, it is enough, Judge Morris, because there's a reason for it explained by competent substantial evidence that the judge made a finding on. The judge specifically found that that testimony was reasonable, the guidelines were appropriate, and remember, Mr. Gilroy, he never even filed guidelines at all. So he didn't file guidelines.
He filed them, he didn't serve them, apparently.
No, he filed a financial affidavit.
But not guidelines.
Didn't serve it, never did guidelines.
Okay.
The only thing this trial judge had before her in this case were the guidelines that we did, the testimony of Mr. Berg, all supported by competent substantial evidence. There's
One of the things you alluded to earlier is the professional relationship between lawyers in these cases and how you say we're going to waive discovery, and typically it's done because one lawyer represents, nothing's really changed, here's what we're going forward on. And the other side says, great, he's moving, so if he had a lawyer, the lawyer would be saying, he's moving, we just need to get that sorted out. What I'm concerned about is if you plead and have this professional discussion before her income changes, what puts him on notice that there is now another issue? And by the way, we agreed we weren't going to exchange discovery, and maybe you told him, maybe you didn't, that no, everything's the same, we're good to go. At some point, and I would never accuse you of this, Mr. Maris, but there are lawyers who occasionally will ambush other people and other lawyers. And the way this is teed up, I am concerned, was he on notice that there is a change and we're going to be pursuing that change? Do you want to do the discovery or not? And clearly it's caveat emptor, he's got the right to do discovery. But if there's this professional approach where, nothing, I don't know what you all said, and that's not part of the record. So I'm concerned about that.
Sure, I can answer the question very easily, Judge. This case is a case that was based on two substantial changes in circumstances that are uncontested. That is, his voluntary, his chosen move to Arizona with his new family. That's number one. Number two, change in who's paying the medical insurance. Those two alone, without doubt, require that whatever the court determines the income of the parties to be at the time of the final hearing, that's going to be the guideline support going forward. And regardless of whether, and I specifically alleged that you have to do that. So there's no ambush, there's no trick. It's a matter of, you better come to court knowing what your income is and knowing what the other party's income is. And what we did in this case is simply not have pretrials, not have witness lists, no tricks. Everybody was in exactly the same boat and showed up at trial, put on our evidence. Judge ruled. Not only did the judge rule, she ruled exactly consistent with the undisputed evidence. So to put that issue to rest, there were absolutely no ambushes. There were absolutely no tricks, no changes, no nothing. It was simply a matter of, pro se people don't necessarily know what to do. But you don't do your discovery. You don't do your homework. You show up at trial, and you then ask the judge, how about another 30 days so that I can get my paperwork together? Of course, had he done discovery
in December 2013, he wouldn't have known about this substantial change. And don't the rules also require advising the other party of substantial changes? The updating of the financials and so forth?
These substantial changes are the medical insurance and the relocation.
Well, the income's a pretty substantial change.
Well, sure, but you're going to base, you don't have to plead substantial change in circumstances of income. You have to prove your income once a substantial change has been takes place. I mean, that's just like one child reaching the age of 18 and not having been dealt with. You don't come back and say, my income's gone down. You come back and say, this is my income now, this is your income now, this is what the guidelines is. That's what we did, that's what we proved. Nothing would have changed. Briefly on the case law, I've given you all several different kinds of cases dealing with this. One of them being, for example, the Vaccaro case. There was never even a financial affidavit filed at all in that case. And in that case, what the court said was, you don't have to just prove that you didn't file a financial affidavit. You have to prove that it would have made a difference. In this case, it made zero difference whatsoever. I understand the argument, was it temporary, was it permanent? Another thing that happened in this case is the judge specifically said, I recognize that this may not be permanent, and we may have to take another look at this at the end of 2014. That's right in the record, something that the judge said. So under the circumstances of this case, based on that representation, I don't think there'd be any need to have to prove a substantial change in circumstances if the income's gone up. But here, the competent substantial evidence 100% supports the finding of the judge. The problem with this case is not having done your homework. I also gave you a variety of cases dealing with, you gotta be able to prove that if the discovery was done, that the result would have been different. And there's nothing here to establish that. I know I've used up more than my time. Thank you.
Thank you. Ms. Grossman?
Your Honors,
Can I ask you a question first?
Yes,
Mr.
sir.
Maris argues, and I think perhaps correctly, that so long as he could show a substantial change affecting the child support in the fact that there had been a move and a change in insurance, that in resetting appropriate child support, the trial court would use current, as of the hearing date, income one way or the other for filling out the guidelines.
Yes.
So he doesn't actually have to prove a substantial change in circumstances like he might for alimony to have the new numbers used in the child support guidelines calculation.
he just has to meet the statutory requirements of the 15
Right.
or whatever percentage.
Okay,
Sure.
okay.
But this is my problem with this case, and I think this exchange between the trial judge and trial counsel sets the tone of this whole proceeding. When Mr. Gilroy's jumping up and down saying, wait a minute, I just got this financial affidavit last night, I'm getting off the plane, there's a 40% change in her income, I need a continuance, and the trial judge looks over at trial counsel and says, well, would you respond to that? And inexplicably, Mr. Merrill says, there's no surprises, there's no changes, nothing is new. I have a huge problem with that, and Judge Silberman, I'm not as diplomatic as you, and I'm not as reserved as you, and I'll take my lumps with Mr. Maris when I leave here, but that is patently not correct. And that was trial by ambush. And yes, Mr. Gilroy is an attorney. He's an IRS attorney. And yes, many pro se litigants don't know what to do. But you know what? Experienced trial counsel do know what to do. And it's not an excuse to have a pro se litigant not follow rules and say, well, I'm not going to follow them either. I would challenge Mr. Maris to point out anywhere in the record from 2007 all the way to the present, anywhere where there's any record evidence in the transcripts or whatever that Mr. Gilroy said, we don't have to exchange any documents. I don't think that's fair to Mr. Gilroy to come to court today and make that representation without any type of record citation. It just should not have happened. We have mandatory rules under the family law. We have 6116, and all of them say you must file a financial affidavit. You better believe if Mr. Gilroy knew that his wife was going to allege that her income dropped from $439,000 to $250,000, he might not have been pro se, and he should have been afforded the opportunity to explore whether or not this is accurate. And that's all we're asking.
One question about that, because had Mr. Maris's client not filed the financial affidavit, your client would have been in the position of an expert coming in to testify as to her current income. And what could your client have done at that point other than say, Judge, this is news to me? And the judge presumably would have said, well, did you ask them for current income? Did you ask them for any of that information? And I'm assuming he would have said no, because it seems like nobody did discovery. The judge would probably have denied a continuance at that point too. And would your client be better or worse off?
Well, I'm assuming that if he were presented with that situation, he would have said, well, you know what? Her counterpetition in her answer never mentioned she had a reduction in income. It was just current income. Had she said, there's been a substantial change of circumstances or my income has been reduced, I would have perhaps proceeded a little bit differently with discovery. But she was never put on notice that. And nowhere does she mention or put at issue his contribution to private school tuition. She just comes in the court and says, that's now at issue. Thank you.
Thank you. That concludes our docket. Court is adjourned.